Hello and welcome to the webinar Doing Business in the Adriatic region. Over the last 2 years, the pandemic has transformed the way businesses operate around the world. Now in 2022, companies throughout the Adriatic region and beyond are still reshaping and adapting to new workplace practices. Our webinar today will cover the imminent risks and future challenges of doing business in Bulgaria and the wider Adriatic region. My name is Haveen and I'm one of the editors here at the Legal 500. Our session today will be divided into 2 panel sessions, which we are very lucky to have so many experts on the panel today, as you can probably see on the screen, from all different regions. The first panel session will cover employment and data privacy issues faced within the office and home office work environments, as well as addressing the challenges associated with adapting working practices within COVID world. In that panel session, we will hear from Nikolai Seventonov, Managing Partner at Penkov, Markov Partners. He's also a member of the Managing Board of Lex Adria. He has represented clients in the field of commercial law, banking and finance law, litigation, corporate law, commercial contracts, financial projects, and tax law. That's just to name a few. Nikolai is just not on screen at the moment, but he will be very shortly. Also on the panel, we have Rados Georgieva, attorney at law at Penkov, Markov Partners. She has a long-standing practical expertise in legal surveys and preparation of legal documents in the area of company and commercial law, tax, labour law, and public procurement. It's great to have you on the session today. Next, we have Dr. Slovan Deslestik, Managing Partner at Legalease. Gajin. I apologize if I butchered that. He is also a member of the Managing Board of Lex Adria. His areas of expertise include corporate and M&A, antitrust, commercial law, employment, and dispute resolution. Welcome to the session.
Thank you, Fabian. It's great to be here.
Next, we have Maria Yankonovska, attorney at law at Georgi Dimitri Attorneys. Her work is concentrated on property law, commercial law, and legal consulting. Welcome to the session, Maria.
Thank you for having me. It's wonderful being here.
Okay, great. So in our second panel session, we'll cover whistleblowing in Europe, starting off with a focus on Bulgaria. The expert panelists who will be sharing their thoughts in this session is Anna Christopher, attorney at law at Penkov, Markov Partners. Some of her practice areas include company and commercial law, copyright measures against money laundering, advertising, medical products, and compliance. Welcome, Anna.
Hi, thank you.
We also have Asan Optoskonov, attorney at law at Penkov, Markov Partners. Some of his practice areas include corporate and commercial law, banking and finance. He's also a leading expert in the field of prevention methods against money laundering and terrorist financing. Welcome to the session.
Hello, everyone. Pleasure to be here.
Also joining the panel is Marko Repka, partner at Doliska, Repka and Gajin. Some of Marko's specialties include dispute resolution, M&A real estate and construction, labour and employment law. Welcome, Marko.
Thank you for this invitation.
Also, we'll get some expertise from Anna Che, attorney at law at UCLA Partners. She's also a member of Lex Adria. Anna is head of the firm's labour law practice and has over 10 years experience dealing with the most complex labour law matters. Welcome.
Hi, happy to be here and take part in this interesting discussion.
Last but not least, we have Petra Lustuka, attorney at law at Viden Law Office. Her work includes corporate law, commercial law, M&A, banking and finance, and labour law. Welcome to the session, Petra.
Thank you very much. It's great to be here.
As you can see, we have a great panel and great sessions ahead of us. I will mention that at the end, the panelists will be taking questions. So feel free to submit them as they come up in our Q&A chat boxes, which you should be able to find somewhere on your screens. Our panelists will be able to view them in real time. Now that the formal introductions are out of the way, we would now like to give a special thanks to Penkov, Markov Partners and Lex Adria for supporting this webinar today. With that being said, I will now hand over to Vladimir Penkov, Chairman and Senior Partner at Penkov, Markov and Partners to provide some opening remarks. Thank you, Vladimir.
Thank you, Harbin. I cannot speak so quick as you, so I would need 1-2 minutes more maybe. I'm happy as well to welcome all to the participants to this webinar. I see from my list that we have more than 160 registered participants from 16 countries. And among many other eminent companies, we have names like Allianz, Bosch, Coca-Cola, General Electric, Henkel, Philip Morris, PricewaterhouseCoopers, Deloitte, Ernst & Young, Samsung, Siemens, Viva.com, Vodafone. I would like as well to welcome especially the German Bulgarian Chamber of Industry and Commerce and Confindustria Bulgaria, who are as well with us. Of course, our distinguished speakers, you mentioned them, Slobodan, Maria, Marco, Anna, and Petra. And of course, Nikolai, Radust, Anna, and Asen from Markov Partners. It is the third time that we have the opportunity and the honor together with Legal 500 to organize such an important event, obviously with great interest. This time we organize this together with different offices from Lex Adria, as the topics are linked with some specifics of the business relations in the whole Adrian region. Special thanks to all the speakers who have taken the time and have made so many efforts to go through such sensitive topics. Surely there are many other tremendously important issues which deeply touch the whole society in each country, like energy prices, inflation, stagnation of growth in the economy, all probably influenced by the pandemic. Nevertheless, I believe that our webinar includes so many topics which have a very special significance. And indeed, do we have any adequate answer to the question in which way pandemic and the measures taken in different legislations could influence or are influencing data protection? Nobody till now has limited the applicability of labor law, for example, and nowhere this has been done. But it is clear that many adjustments must happen. Who, when, and under what circumstances have the right or even is obliged to go the home office modus? Are there queries related to the green certificates or the testing procedures accordingly? May we request same data from our visitors in the offices? What are the risks for the working environment? And is the working environment, or could the working environment be a priority in our life and in the measures? What are the additional requirements when using the home office modus? At the same time, we are providing full access to all our systems and information systems. What are the vehicles, on the other hand, of the employer, being at the same time responsible all the day long, supervising employees during the working hours, including as well measures of healthcare and so on? The first panel concerns exactly these aspects and many other questions. And as you mentioned, both panels shall be led and moderated by our managing partner, Nikolai. The second panel is dedicated to whistleblowing. Where and under what conditions one could deliver such information? What are the criteria? As we know, people differ very much, different approaches, different level of knowledge, and so on. What could be the meaning and importance of a report from a particular whistleblower, taking into consideration, for example, that there are cases like Bulgaria, what would maybe shall happen in Bulgaria and in other countries, that anonymous reporting may be allowed. How such information could influence negatively the businesses, the companies, and who shall take the responsibility for this? Do we underestimate the existence of so many official state authorities, controlling authorities, which are dealing with these questions? And we know that SMEs, even with more than 50 employees, are more sensitive than large businesses. Is this, or could this be a case of overregulation, which is destroying the quality of economic possibilities? We must take into consideration another important issue as well. In this region, we know the bad practice from the communist times, only 30 years ago, before establishing democratic society and entering the free market economy. Could this influence the approach of the people, saying and calling this snitching, which we must avoid as well? Often the responsible authorities in practice could not stop leak of information when checking reports of whistleblowers, besides the regulations. Last but not least, how would the practice face the circumstance that different measures prohibiting bad practices are regulated in the European Union in different pieces of legislation, such as public procurement, transport, safety goods, money laundering, and many others? Could any expansion of this frame be helpful for us? These are some of the questions which I expect, and maybe all participants would expect, to listen to the answers to the distinguished speakers in the panels, and that's why I'm giving the floor to Nikolai to moderate the first panel. And we shall change the chairs.
Good morning, everyone. Let me just speak under the correct name as a start. It'll take just a second. So thank you very much, first of all, for joining us in this interesting and challenging discussion in the first panel today. As already mentioned, we will be focusing in this part on the webinar on the COVID consequences on the working processes. In particular, we should discuss the work from home implications regulated mainly by the employment and data privacy legislations. But to be able to explain why this topic is so relevant, let me first share with you a few statistics. In developed markets like UK, Germany, and France, for example, before COVID, approximately 5% of the workforce worked mainly from home. On non-developed markets like Bulgaria, as an example, this percentage was as low as 2%. About 8% of the EU workers have occupations, even currently, that are suitable for work from home. Before COVID, around the world, about 44% of the companies was not allowing any remote work. In 2019, there were about 4 million remote workers in USA, or 2% of the entire workforce. Still, still 40% more US companies offered remote work. There was some mixing of voices. Offered remote work as an option in 2019 than they did 5 years ago. Then 16% of the global companies are actually 100% remote companies at present. Globally, 52% of the workers work from home at least once every week. And finally, 86% of the people that work remotely reduced. I think that we are mixing some Serbian language or Croatian language, I don't know, with the panel.
Ja sam preko kompjutera, tako da bolno mi je otvorilo.
Sorry, can you please mute yourself, whoever this is or this was? Thank you. You see that the above statistics illustrate the new reality. Indeed, the country percentages are different around the globe in terms of people working from home, but this depends on the structure of each economy. What is clear for all of us is that in the past 2 years, everyone whose work allowed to go in home office, at least for a while, did it and will continue doing it. So as a start in this panel, maybe we should discuss some data privacy issues which were quite sensitive for the business on the Balkans and were intensively concerning the data privacy processes. So maybe the first important question was for the business, whether it is allowed to process sensitive personal data related to the health status of the employees and visitors of premises. I will give the first answer, and it's from the Bulgarian law perspective. It's very rapid and it's no. Such data processing is not considered as a right by the Bulgarian regulators. It only comes as an obligation and for explicitly specified in the orders of the health minister data controllers. The ground for these viewpoints was found in both the European and the Bulgarian legislation. So far, in the health minister's orders, he has only obliged some controllers from the tourism and leisure industries to collect data related to the health COVID status of visitors and employees. The industry in Bulgaria, though, had some problem with these concepts, and good point was raised by the production facilities, because they are not mentioned in the orders, respectively, they are not allowed to collect such health data, and that prevents them from imposing some higher health standards by, for example, asking employees to present certificate or to be tested when coming and visiting working premises. Just like in the shopping malls, on the other hand, these employers have in one common space a lot of personnel, usually as a mandatory part of their normal course of business. In some cases, it might be even dangerous because the decrease of number of people could influence operating certain very important machinery. Having said the above, it came quite as a surprise that the industry was restricted to implement such higher hygiene measures, health measures, like, as I mentioned, mandatory testing or checking at least the vaccination status of the people coming at the premises. What was allowed in Bulgaria was first to collect by means of anonymous and voluntary approach some statistical data on the percentage of vaccinated employees using tools like questionnaires and the assistance of occupational health service. And second option was at the entrance of the facilities to ask, but totally on a voluntary principle, the visitors and employees to present green certificates without keeping, of course, any record on the personality of the certified individuals. So that was quite restrictive and prevented, as I mentioned, the opportunity for the industry to increase the hygiene measures. But that's only the Bulgarian perspective. And I was wondering now if perhaps Slobodan or Marko could give their Serbian perspective on this topic.
Thanks, Nick. Slobodan is here, and I will be happy to follow up on what you have said. I think that this topic is something which is extremely important nowadays, and I think it's a great thing that we have raised this and that we have the opportunity to discuss this today and to see a little bit regional perspective how these things work. As you have said, the law still continues to apply in the times of crisis. And obviously that goes with the personal data protection law. Our personal data protection law in Serbia is very much modeled based on the GDPR. And the rules applicable here are pretty similar to what you have also in the EU countries. Any processing of personal data, and obviously in the context of this pandemic, this becomes more and more important because employers wish to know and wish to follow the health situation of their employees, the risks that are associated with that, and obviously this has become now something which is, I would say, of very high importance for pretty much all employers, especially those of bigger scale, not only in Serbia, but in the wider region. Now, under the data protection law, what employers can do, they can process personal data of their employees on the legal grounds which are allowed for under the personal data protection law. And basically, just to mention a few, this is on the basis of a consent of an employee, or when this is necessary for the vital interests of life importance, or when this is necessary for the legitimate interests of the employer as data control. But the tricky part comes into play with the provision of the law, and I think this is similar also in other countries, which stipulates that health issues are considered as particularly sensitive information, and their processing is generally disallowed, and it is only permitted in a small number of exceptional cases, and I will just mention two of them here. The first one is when there is an explicit consent of a person, of an employee, for processing of his or her health data. And the second is when a collective agreement with the employer regulates terms and conditions for processing of such data. So Serbian law here gives a little bit of freedom to employers to regulate through collective agreements, whether and on what terms and in what manner personal data related to the health status of employees may be processed. But obviously, it is always necessary to have in mind this principle of proportionality, and that this always has to be reasonable and justifiable, and that the employers always have to be able to explain the rationale behind this data processing. Now, going just briefly to several practical issues that often happen and that we are often asked by the clients, practically what they can and what they cannot do is, for example, we often get questions whether they can keep records of vaccinations of their employees and vaccination status of the employees. And unfortunately, the answer to that most often is that this is not allowed without this explicit consent of employees in this regard. What employers may do, however, and this is what they often tend to do, is to have, for example, measuring of temperature of employees and other persons entering the premises of their companies, or when they have bigger scale meetings, to have a look and to inspect this COVID certificate that practically demonstrates fulfillment of legal requirements prescribed by the authorities in Serbia for organizing meetings which are attended by a larger number of people. So practically, yes, this is one topic which is quite difficult and is really something which is of great importance for all employers. And I look forward to continuing this discussion with the more specific issues to come.
Thank you. Thank you very much, Slobodan. And maybe Maria should also give us some aspects on the same question from the Macedonian legislation.
Yes,
Macedonian legislation.
I was listening carefully to my colleague Slobodan, and I can state that the situation in Macedonia is pretty similar to the one in Serbia. We have a new law on protection of private data that has come into force in August 2020, and we intend with this piece of legislation to cover as much of matters covered in the GDPR as possible, because we are still not a member of the EU. So the basis for collecting personal data from employees are rather the same as the ones stated by Slobodan. Existence of legitimate public interest, or interest of the employer, or need for execution of the employment contract and similar. However, a distinction we have, which may be a characteristical to our country, is the opportunity provided by the law on protection from infectious diseases. This law was amended when the pandemic started, so to enable different types of employers that have a vast number of employees to perform COVID testing and request more deep insight into the personal data of their employees. Prior to this amendment, this opportunity was only granted to certain specific industries, like the food production industry, catering, or pharmaceutics and similar. However, with this amendment, whenever there is a general danger or a reason for the employer to suspect there might be a danger from an infectious disease, they can introduce testing in their premises without explicit consent from their employees. However, we have advised our clients to request and acquire specific consent from their employees, just to cover all the reasons and the prohibitions provided by the law on personal data protection, and to always be on the safe side that they are not digging too deep into their employees' privacy and health status. It was also a practice in Macedonia throughout these 2 years, 2.5 years of pandemic, to measure body temperature, not only of the employees, but also on all incoming visitors to employers' premises. But it was done, and it is still done, on an anonymous basis, meaning that the data is not retained after the visitor or employee is granted access into employers' premises. The same was done with certain questionnaires requiring information from visitors and employees of whether they have traveled recently, on the countries they have traveled to, or if they have had a contact with a possibly COVID-infected person. So these are also taken anonymously until it has been evidence that some of the answers impose danger to the others, and then another additional measures are undertaken. We had also a certain decrees granted by the government during 2020 and 2021 that imposed restrictions such as wearing masks on the on working premises and similar.
Sorry, Maria. Speaking about the working premises, what were the employers allowed to collect as a data from those employees who were actually working from home? And I will give you a few examples. Were they allowed to maybe install a video camera on the equipment of the employee? Were they allowed to access his PC or the working email, the office email? Was that allowed in Macedonia? And is it still allowed? Yeah.
Yeah, it is a very interesting question. We had this question imposed by several clients. First of all, let's go with the most sensitive issue, and that is video recording and video surveillance in the employer's house. Pursuant to the Macedonian constitution, the workspace, I mean, the home of the employee cannot be surveilled. So for that reason, the employee should grant a specific and explicit consent, and we do not advise for the employers to request it. As long as there are additional or other different types of measures of surveillance they can impose. They can have software that records the activity of their employee on a certain platform. They can also have insight into the email address of their employee, as long as that email address is registered as owned by the company or by the employer. Then it is considered as an asset of the employer, and they can access it without any prior notification or any specific reason to do so. However, they cannot access to employees' personal, let's say, PC or laptop, as long as that laptop is in personal ownership of their employee. So in order to avoid those gray zones, we have advised our clients, if possible, to provide equipment to their employees, let's say laptop in ownership of the employer, so they can have full access on the materials they're on, to provide secure VPN address that they can later on inspect if anything or any reason occurs to do so, and similar. However, video recording is still very much not applied here in Macedonia, as it may be considered unconstitutional.
So the regime seems pretty similar to what we have here in Bulgaria, with the clarification that if it is necessary and you have the written consent of the employee, you may still install a video camera on his working spot, if I may say so. So you may not get into the private life of the employee, but you may still record his daily routines in terms of working. So I was actually wondering, how is it like in Serbia? Is there like a total similarity in these processes, or it's different?
Yes, Nick, this is actually quite similar to what both Maria and you have said. And obviously the most difficult question is the question of video recordings and video surveillance. And here, in terms of Serbia, we make, we may make differentiation between making video surveillance in the employer's premises and at the employee's home. Mm-hmm. And, as Maria said, and as you said, obviously making video recordings and video surveillance of the employee's home is something which is generally not allowed. And we tend to advise clients to be very careful if they want to do that. Formally, this could be possible with the explicit consent of the employee, but even with an explicit consent of an employee, this may be a tricky part, because you may also catch in video some members of the household, or some other personal data of some other individuals. And this is quite difficult to control. So this is something which is, I would say, very risky. And to my knowledge and my experience, most of employers in Serbia do not do that kind of things. This is also so because our data protection authority has a practice that employers may only make video recordings and video surveillances of the processes of work and not of individual employees. So if you're making video, yeah.
It's actually absolutely the same in Bulgaria. And by the way, that's a very good bridge to maybe some labor aspects of the remote work. Mm-hmm. And I was wondering if we could now involve Radost in this discussion, and if she can share with us some specifics which should be considered in respect to the so modern remote work, maybe as a consequence of the temporary and crisis COVID-19 legislation, which is still applicable. So Radost. If not, then maybe we could have the other lady, maybe Maria, to respond to this question.
Okay. Can you hear me now?
Yes, yes.
Okay. Nice to be here with all of you. So we should agree that remote working is related with many challenges, practically and also legal challenges. And one of the challenges is, of course, related with the inefficiency of the employer's control while working remotely. So we have spoke that according to the Bulgarian legislation, okay, it is possible to install a video camera, but my personal opinion that such a solution may be not appropriate, because it is for me closely to a Big Brother arrangement. We are talking about a camera installed within the household of the employees. That's why to enable employers to have a better control, to keep eyes on their remote workers, appropriate solution should be, as Maria mentioned, to introduce some software monitor tools. Such tools are currently offered by many companies as a whole product, and they allow employers to assess idle time, active time, to estimate how many time has been spent on productive and non-productive webs and apps, how many time has been spent on completion of certain tasks. And so enabling the employer to introduce some measures to improve achievements of employees and to increase their efficiency. So, as per the Bulgarian legislation, remote work is now allowed, may be introduced upon agreement of the parties and by an order of the employer. The last option has been introduced in 2020 as part of the anti-crisis measures around COVID-19. And in the meantime, remote work became a very important tool for employers, enabling them to ensure business continuity, but at the same time to counteract COVID-19 spread, to prevent transmission of the virus, and what is important from perspective of the employees, to provide them greater flexibility, so to the employees to be able to have enough time to complete also non-related tasks and duties to family members, friends, and relatives. As I mentioned, one of the biggest problems while working remotely is the limited possibility of the employer to exercise control. Combined, of course, with the need to protect the privacy of the employees. The other issue is related with the age and safety rules, of course, because on the level of health and safety, there is no change, there is no difference, and the rules and the duties of both parties under the relationship remain the same as if the work were performed from the traditional working places, meaning that the employer is under obligation to provide health and safety, to assess the risks of the work environment, which is of course related with the necessity to visit maybe the household of the home premises of the employees. This has not been done, of course, in the first days after the first lockdown, because it was difficult to expect from employees that they will grant access to external persons, being focused to protect their own health and the health of
because after all, that was the entire idea of
yes,
from home.
Yes, there are no limits in the obligations of the parties as regards health and safety, although there are limits in their possibility to fulfill that obligations while working remotely. So in the meantime, employers supported by the occupational medical services found some flexible tools to evaluate the risks when employees are working from their homes, such as to use pictures taken by the employees, to provide online health and safety trainings using videos with information that combines both funny and serious aspects of the safety rules. But observance of the health and safety rules is related also with the responsibility of the employer in case of an occupational accident that may happen, of course, also when working from home. And this is one of the biggest problems because we have a very wide formulated definition of labor accidents that includes.
Speaking yes. About risk prevention and H&S duties,
yes.
voice in
yes.
remote workers, will you allow me to give the floor also to Maria to share some Macedonian, North Macedonian law perspectives on that?
Just to sum up, the same health and safety rules apply for remote workers and their employers, notwithstanding, regardless the fact that the access to the work floor is very limited for employers and also for the controlling authorities. And I suppose the situation would be not much different also in other countries.
I guess so, yes. So let's see. Maria?
Thank you, Nikolai. As opposite to personal data protection, working from home is a rather unregulated issue or under-regulated issue in Macedonia. There are a couple of provisions in our labor law that enable the employee and the employer to agree on performing work from home and impose certain terms that should be successfully realized in order for that agreement to be considered legal. In that regard, the agreement should be, of course, in writing, and the work from home should be reported to the labor inspector. And that's it. The labor law is silent on the measures of protection that the employee and the employer should agree between themselves, or what kind of those measures could be imposed, etc. And the main issue here, as Rados already mentioned, is the control that the employer cannot perform over their employee and the environment and surroundings in which the employee performs his duties. Therefore, a couple of months back, in 2021, there has been a formal letter to the labor inspectorate and a request for them to further on provide details on how the liability of the employer for damage occurred to the employee at their house while performing housework could be determined. And that letter could be summed up in a couple of conclusions. First of all, it should be proved that the damage was caused due to reasons that are related strictly to the performance of the work. And further on, that the employer shall be liable only if they exercise all available protection measures. So in order to protect our own clients, we advise for them to provide distinctive and detailed manuals or guidebooks and similar to their employees on all aspects of protection and mitigation that employees could implement in their own households. Further on, it is absolutely compulsory for the employers to provide personal protection gear or equipment, if that applies to a certain job position, to provide safe and inspected equipment, including IT equipment and similar. And we are still waiting to see what the stances of the courts will be once we receive verdicts that are final and binding and that apply to this kind of occurrences.
Maria, we have, as you know, one doctor in this panel, and he's from Serbia. So we should ask him maybe about his perspectives on that same question.
Yeah, I will be happy to give you my diagnosis. So in terms of Serbia, work from home is explicitly regulated under the labor law. And the labor law says that this is first something which must be the matter of agreement between employer and employee. So this is not something where employer can force employee to take this, or employee can demand to be granted work from home. So practically this must be the matter of agreement between employer and employee. And secondly, this must be regulated in the employment agreement or in an annex to employment agreement. And in such cases, the law says that employment agreement must have certain additional mandatory content which must be regulated in the employment agreement. For example, duration of working hours in correspondence to the normatives and requirements of work. Then how is the work of employee going to be supervised? What means of work will be provided by employer? What means of work of employee will be used for work from home? How will employee be compensated for the cost that he or she has when working from home, and so forth. Importantly, the labor law also sets two important conditions for the work from home. First, in the first place, employees who are working from home cannot be discriminated in terms of salary, which means they cannot have lesser salary than employees working from the employer's premises on the same jobs. Secondly, the law says that the volume of work of employees who are working from home must be determined in such a manner not to practically prevent employees from using their daily and weekly rests from the work. Now, in terms of health and safety for employees who are working from home, this is obviously a very difficult question, and a question that has raised a lot of questions in practice. And as a result of that, Serbian Ministry of Labor has issued last year in 2021 guidelines regarding the health and safe work from home. And these guidelines are quite practical and useful, I would say. And I would advise, everyone who has interest in this topic regarding Serbia to simply find those guidelines. They can be easily found on the internet. And there you can see, in the first place, how the ministry perceives this issue of health and safety for the employees who are working from home. And secondly, in the attachment to these guidelines, there is a control list which practically serves as a very helpful tool to employers who are organizing work from home in order to be able to make risk assessment for all those employees who are working from home. What is a question that we often get asked from clients is, are they obliged to include work from home in their so-called acts on assessment of risk for all employees, which is mandatory in Serbia? And the answer to that question is, for example, provided in these guidelines of the ministry, where they explain that in their view, such workplaces, meaning workplaces where employees work from home, they can be, but they don't have to be, including these risk assessment acts. And this is also something.
Maybe, Nikolai, sorry, I should something. According to the Bulgarian law, risk assessment, for example, should be conducted in any case where there is change of the working place. And working remotely means, of course, that employees will switch from traditional workplaces to workplaces outsourced from the company's premises. And in this case, unfortunately, I would say, this is mandatory to conduct. And also, employer should not only conduct risk assessment, but afterwards introduce some measures and provide briefings, agent-based briefings and trainings, and document that briefings and trainings in a special book that currently exists in paper form only.
Just a quick summary. Obviously, we are quite similar, not only from linguistic point of view, but also in terms of temper, in terms of many other things. So maybe the guidelines in one of the countries that we represent would be interesting for the others, so that we can share some wise thoughts of our authorities. And with that, let me just ask you one final question, because we are quite advanced with the time. And I would rely on your very rapid answers. So that last question is, what happens with the occupational accidents when working from home? Maybe, Radost, if you can just give us a very quick answer so that we can compare it with the other jurisdictions.
Yes, this is also a very sensitive issue with occupational accidents because, as I mentioned before, we have a very wide formulated definition of what is work accident. And work accident is any accident that happened during performance of assigned work in connection with or because of the performance of the assigned work, but also any work which has been completed in the interest of the employer. Commuting accidents are also part of the work accidents as per the Bulgarian legislation. There are no specific rules according labor accidents happened while working remotely, although in the previous year the former labor minister Sacheva suggested such specific changes to be introduced in the labor legislation according to the question with regard to the questions related to the labor accidents that may happen while working remotely, meaning that there are many questions and there are many difficulties that employers may encounter, especially with respect to the investigation of the labor accident. It will be quite difficult for employers to collect necessary evidences because according to the Bulgarian legislation, the employer is still, in any case, liable for the damages suffered by an employee who has been injured as a result of a labor accident, meaning that that liability may not be excluded but only limited. And in this respect, this is very important for the employer to be able to provide evidence that the employee has somehow contributed to the accident and thus to reduce the liability of the employer. To conduct an in-depth investigation means that employer and maybe also the controlling bodies should visit the premises of the employee, which is also an issue. There is another difficulty related with the correct qualification. Yes.
Sorry, but we are into the time of the second panel already. So maybe just a quick response on Maria, who I suppose could work with you in a team just to summarize the local specifics. So Maria, what about North Macedonia?
Yes, as I mentioned previously, as an underregulated area, we have quite a bit of difficulties to advise our clients on this topic. As Radoslav also mentioned, the issue of the employee also adding additional reasons to the damages should be considered in our legislation. So even if it's not possible for the liability of the employer to be reduced or totally declined prior the damages occurred, it is possible for the employer to prove that the employee did not follow all the instructions, did not use their protective equipment, or did anything additional and caused a certain amount of the damages by themselves.
Quite the same as in Bulgaria. And what about the diagnosis of the doctor?
Yes, Nick, it's quite very similar to Macedonia and Bulgaria. So the notion of occupational accident is very broadly defined. It's practically any accident happening in connection to the work employee does for the employer. So yes, definitely an accident happening during the work from home can be considered as an occupational accident. And if that happens and if the dispute gets to the court, then of course it's a practical question of potential contribution of the employee to that accident, and it's up to the employer then to prove that they have done everything they could in order to mitigate the risk, and then the court would assess whether and to what extent the employee contributed or did not contribute to the accident that happened.
So thank you all for this teamwork in this panel session. For me, it was quite interesting. I hope that the audience would also find it informative. And we are directly jumping into the second panel discussion. It's dedicated to the whistleblowing. and not to the snitching, as Mr. Penkov said in the beginning. In the first few minutes of this panel session, my colleagues Anna and Sen will sum up their overview on the whistleblowing regime, which is set out in the directive, and some of the implementation issues and challenges that we are expecting to be facing in this regard. So Anna, Sen, may I ask you to start with your presentation?
Yes, thank you, Nikolai. Thank you all for the interesting discussion which just took place. Me and Anna, as you said, we will try to present briefly our view on the transposition of the whistleblowing directive on local level here in Bulgaria. I'll now try to share our presentation, as I hope that everyone could see it. I'll need just a few seconds. Okay, I hope now everything is fine. So I can imagine that this topic, the whistleblowing, will become, I would say, more and more important all across Europe in the coming months due to the simple fact that the deadline for transposition of the whistleblowing directive in Europe in the different member states has already passed. It was 17 December last year. Through our presentation, I would say that we'll try also to give appropriate platform for the discussion, which is to follow our take. Frankly speaking, for us, it's a pleasure to participate in this panel, as we're really looking forward to hearing also valuable insight on this topic, also from the other speakers in a few minutes. So first, maybe a few words about what is happening in Bulgaria, what is the state of play here locally. As I said, Bulgaria, as every other member state, had to implement the directive up until 17 December last year. Well, we're still not there yet, as we do not have an adopted law. Actually, the Bulgarian Ministry of Justice already conducted kind of initial first round public consultations on a draft bill for transposition of the whistleblowing directive, which draft bill, however, was, I would say, very, very general, and in practice it did not give any indications on the particularities, details, and the manner in which the directive will be transposed in the Bulgarian legislation. So we still do not have an adopted law, but the expectation in the sector is that literally in the next few weeks we'll have such draft published, and a second round of public consultations will also take place, will also be conducted. Back to the regulatory regime, an important aspect in any case on European and of course on Bulgarian level is who can actually be a whistleblower. That is definitely something that will be transposed in Bulgaria. So it's interesting to check the understanding of the directive in this regard. Whistleblowers or reporting persons shall be natural persons who reports or publicly discloses information on breaches acquired in the context of his or her work-related activities. I would say, evidently from the definition, the scope of whistleblowers is quite broad, as the directive, I would say, goes even further and provides for certain specific categories whistleblowers. For example, here we have employees, workers, which is probably the main category, reporting persons. We also have self-employed natural persons, volunteers, shareholders, members of managing and supervisory bodies of companies, and so on and so forth. Interesting category whistleblowers, from my personal perspective, especially considering the local situation here in Bulgaria, are subcontractors and suppliers who will also be entitled to submit reports for potential breaches of the legislation and who could also benefit from the protections provided for in the directive. The European Act goes further even, envisaging protection also for third persons who are connected with the reporting persons and who could also suffer retaliation. such as colleagues or relatives of the reporting persons, as well as legal entities that the reporting persons own or work for. Obviously, the broad scope, again, of the whistleblowers puts an interesting perspective, I would say, to the whole regulatory regime, and in a way, it just poses questions on the practical application of the new legislation on local level. Speaking about whistleblowers and reporting, inevitably another important topic comes to mind, another important question, and it is related to the grounds which should exist in order for an employee, a worker, let's take for example, to be entitled to benefit from the protections laid down in the directive. Summarized, I would say the whistleblower should act in good faith. The directive envisages, of course, certain protections for the reporting persons when they report potential breaches of the legislation. At the end of the day, this is one of the main aims of the directive, to give such guarantees. Naturally, probably, in this context, the question arises in the cases where, due to certain reasons, a worker may have probably a negative attitude towards its employer, meaning that this employee intentionally could report misleading information, wrong information, with the sole aim to harm the company or cause some kind of reputational damages, for example. Again, in this context, the directive provides for that the whistleblower should have reasonable grounds to believe that the information on breaches reported was true at the time of reporting, and that such information, of course, fell within the scope of the directive. This requirement is, in my opinion, like a safeguard against bad faith reports, as it ensures that those employees who have reported in bad faith with intention to provide misleading information could not benefit, of course, from the protections given in the directive. We'll speak in a few minutes about this. In turn, and at the same time, those employees who have reported misleading, wrong information unintentionally, of course, could benefit from these protections. Thinking about this, maybe at the end of the day, it's about finding balance between the interests of the organizations and the protections which the directive provides for the employees. On this background, also another important topic comes up. Many of the persons falling within the category of whistleblowers naturally have also kind of non-disclosure, confidentiality, loyalty clauses in their contracts. In these cases, the directive provides for that, and this is something that will definitely be transposed on local level. The directive provides for that in case of good faith reporting, these employees won't incur any type of liability, neither civil one, nor criminal, administrative, employment related, etc., etc. So speaking about violations of the law, of course, it is important to mention what is actually the procedure for such reporting of breaches of the legislation. So I'm now giving the word to Anna, who will share some thoughts here.
Thank you, Asen, and hello again, everyone. So the general framework concerns protection of persons who report or publicly disclose information about breaches of the law. But how does this reporting happen? Basically, as you can see, there is a three-tier system in place, which includes internal reporting within the entity, external reporting to the authorities, and public disclosure before the media. Something that concerns the business here is that legal entities, both in the private and the public sector, should envision internal channels and procedures for reporting. As a general rule, companies with 50 or more workers should have such procedures in place for reporting and following up on reports. These functions may be assigned to current employees, such as legal advisors, data protection, or compliance officers. As the case may be, functions may be outsourced to a third party, like some kind of platform provider or counsel, and even an auditor. From a legal perspective, if such functions are assigned, for example, to a law firm servicing the company on different matters, a conflict of interest may probably arise. In any case, this aspect should be considered in view of the requirements for independence, confidentiality, and secrecy. Provided that, however, the requirements set out in the law are met, it is up to each legal entity to determine the particular mechanisms for reporting. How reporting may be done? So, reporting and signals may be filed by post, by physical boxes, online through internet or intranet platform, by telephone or other voice messaging systems, and even by means of physical meetings if the whistleblower requests so. Another important aspect is the obligation to follow up on the filed report, in other words, to provide feedback to the reporting person. As regards external reporting, member states are obliged to envisage authorities which will have competencies overseeing whistleblowing. Member states should also ensure record keeping of the filed reports and the follow-up. On a local level, as Bulgaria still does not have regulation on whistleblowing at present, it remains to be seen whether different authorities will have competence on whistleblowing or functions may be entrusted to a centralized authority. As seen across member states, both of these approaches could work. For example, the Netherlands has Dutch Whistleblowers Authority overseeing whistleblowing. Functions may also be assigned to already existing authorities, like some kind of bureaus, committees, law enforcement agencies, and anti-corruption bodies, for example. The last and third tier in the reporting system is the public disclosure. Here we imagine each and any channel or platform aimed at the general public, like television, radio, and even social media like Facebook and Twitter. Of course, this is the signaling method that provides the most publicity, and as it seems, the one that could have the most serious impact for the company. Even if there is no real breach, the reputational damages and consequences for the companies may be really serious. The reporting person should be able to choose the most appropriate channel depending on the individual circumstances of the case. Speaking about cases when there is no real breach, persons who publicly disclose information should enjoy protection only when certain criteria are met. Namely, when they have reasons to believe that the breach may constitute danger to the public interest and there is an emergency situation, or if there is a risk of retaliation and a low prospect of the breach to be effectively addressed. So, in other words, the whistleblower has the right to choose, again, minding the specific circumstances of the case, whether to report internally, externally, or to publicly disclose information about the breach. So the whistleblower is not obliged to exhaust all the channels in some specific manner in order to publicly disclose information. We have mentioned retaliation and that whistleblowers enjoy protection from it. It should be said that potential whistleblowers are often discouraged from reporting for fear of retaliation. Retaliation includes some standard acts such as suspension, layoff, dismissal, reduction in the labor remuneration, unfair treatment, or even harm, including to the person's reputation in social media, blacklisting, and so on. There, however, should be a close link between the reporting and the treatment suffered. In other words, employers should not be prevented from taking employment-related decisions which are not prompted by the reporting. Now, back to Asen.
Thanks, Anna. Speaking about the directive, as already mentioned, the European Act lays down certain specific areas of the law for which breaches of the legislation could be reported. Summarized here, we have transport safety, product safety, consumer and data protection, public procurement, protection of the environment, and so on and so forth. Saying that, however, one should know that each member state will have the discretion to decide whether this scope of legal fields to be broader or not. In other words, whether to comply with the minimum standards of the European directive or to envisage broader scopes of these legal fields. From my perspective, this is of utmost importance when considering the transposition of the directive on European level in each member state, and of course also on local Bulgarian level. At least from my experience, I may say that we are usually trying to transpose the European directives in a strict manner, where we comply with the minimum standards provided for in a certain directive. However, of course, there are certain exceptions. Here, I may give as an example, more or less a recent example, the transposition in the Bulgarian law of the 4th and the 5th anti-money laundering directives in the local Bulgarian Measures Against Money Laundering Act, where we have laid down standards which I would say exceed the minimum standards provided for in the European legislation. And finally, maybe a few words about the obliged entities. Obliged entities, who is actually obliged under the directive and the respective local laws. As a general rule, these should be legal entities in the public sector, as well as, on a separate legal ground, legal entities in the private sector. There is, I would say, kind of separation when it comes to the obliged entities in the private sector, and entities as follows, as shown on the slides. Legal entities with 50 up to 249 workers should envisage internal policies and procedures in their companies, in the respective company, up until 17 December 2023. So there is like a 2-year transposition, I would say, period, term. As far as legal entities with 250, however, or more workers are concerned, the term was the general one for transposition of the directive in each member state. In other words, 17 December 2021, or of course, the moment of transposition of the directive in the respective member state. As far as I'm aware, the directive has not been transposed in, I would say, most of the member states at this moment in time. Of course, there are specific thresholds which may apply for entities in different sectors. The financial sector is a good example in this regard. Member states will also be allowed to determine that legal entities in the private sector with less than 50 workers should establish internal channels for reporting. This is important. Evidently, such approach will mean that the scope of the obliged persons in Bulgaria, for example, will be broader again than the minimum standards of the directive, which of course concerns the business directly. Each company in practice should make an assessment and analysis whether it qualifies as an obliged entity under the new legislation, respectively, whether it should establish and create internal policies and procedures in the whistleblowing field. So basically, this is the end of our presentation. Thank you all for following us. Of course, we'll be glad to answer any questions on what we've just discussed. And now I'm giving the word back to Nikolai, who will, I guess, moderate the next part of this panel.
Yes, thank you, Anna. Thank you, Asen. It was quite interesting to see and to hear your perspectives on the transposition of the directive. And what we maybe should do firstly is to check what is the status of the transposition in the other countries which are represented in this panel by Anna from Slovenia, Petra as well, and Marko from Serbia. So maybe Petra, what is the status of the whistleblowing directive transposition in Croatia?
Yes, hi, hello everyone once again. I'm pleased to be part of this interesting discussion. And as an introduction, please let me provide you with a brief summary of the whistleblowing legislation in Croatia. Namely, I'm happy to share with you that in Croatia there is a universal law on whistleblowing, which is called the Act on Protection of Irregularity Reporters. What it is important to point out is that this act has entered into force on 1st July 2019, meaning few months before EU adopted the whistleblowing directive. And therefore, this act is not 100% harmonized with the EU directive. But regardless of the aforementioned, the Act guarantees certain level of protection to the whistleblowers, as certain protective mechanisms provided by the directive are contained also in the existing Act. For example, this Act also recognizes three-level reporting system, including internal and external reporting channels, as well as public disclosure of irregularities. In that regard, public and private entities employing at least 50 employees are obliged to establish an internal whistleblowing system, while the ombudsman is designated as the external reporting channel. Besides, the Act also prohibits that the whistleblower is put in an unfavorable position as a result of reporting irregularities, and guarantees judicial protection to the whistleblowers. But however, as I have already mentioned, the existing Act is not completely compliant with the EU whistleblowing directive, and therefore the legislative changes are ongoing in Croatia. Given the number of amendments foreseen, actually it was decided that the new law is needed rather than amending the current one. So in that regard, the proposal of the new act has been approved by the Croatian government on 15 December last year and submitted to the Croatian parliament. And actually following to that, the first reading of the proposal was on the agenda in the parliament just 2 days ago, meaning this Tuesday, while the voting is scheduled for tomorrow. So we will see what will happen. We are still expecting the second reading of the final proposal. And this means that hopefully in the next half of this year, the new act will be adopted.
Thank you very much, Petra. Anna, let's be gentlemen, at least in this second panel, and start with the ladies. Is it also so dynamic in Slovenia, like in Croatia?
Well, let me tell you that Slovenia is one of the many European countries that did not manage to transpose the directive in due time. So our regulation of the whistleblowing up to this day is still rather fragmented and governed by various acts, such as the Integrity and Prevention of Corruption Act, the Banking Act, the Slovenian Sovereign Holding Act, the Employment Relationship Act, as well as the Inspection Act. So we do not have the definition of a whistleblower as such. We don't have a general obligation of public and private entities to establish reporting channels. However, some sectors, in particular the financial sector, are already under the obligation to have functioning breach reporting systems. If we say about the employment legislation, does not contain specific provisions on whistleblowers. However, there are certain provisions which are to be interpreted in a way to order some protection against retaliation measures to whistleblowers as well, such as provision against unlawful termination, provisions on equal treatment, provisions on prohibition of discrimination, harassment, and mobbing in particular. So with that being said, the draft proposal of the legislation was already published to the interested public, and the consultations were ongoing. I believe the deadline for the remarks was 10th January this year. And the legislation is expected to be adopted somewhere spring 2022. However, with that being said, the draft was heavily criticized, and we have parliamentary as well as presidential elections this year. So it's hard to say with certainty whether this deadline will be met or not. If I move to I will not go into details on the draft because it is in its early stages and it might be heavily amended still. But let me just outline a few, let's say, rather interesting provisions. For example, as Asen was talking, in Slovenia, we have expanded the obligation to establish internal reporting channels to companies in the fields of healthcare and protection of environment, regardless of the number of their employees. We let's say define the number of employees to 50. However, this number is only to employees, not workers, because the statistical number the statistics in Slovenia are related only to the number of employees in the company, not potential self-employed people, workers, students, and so on. The deadlines for companies with less than 250 employees is the same as in the directive, 17 December 23. But for larger companies and for competent authorities for external reporting is set at 60 days after the date of entry of the proposed legislation. So basically, it will be much shorter for those institutions and companies. And then we have we will not be dealing, well, according to the proposed legislation, with anonymous reports. Those will not be subject of the whistleblowing legislation unless the identity, of course, of the reporting person is later revealed. Then we have also another specific provision that reports filed after 1 year or more after the breach has ended will not be subject of the whistleblowing legislation if the person dealing with the report will, let's say, evaluate that that there were no consequences, or that the consequences do not exist anymore or are insignificant. And then another important, I will, let's say, end with this, the fines for breaches. So of obligations defined in the draft legislation for individual persons, for example, for malicious reports, are set in the range of up to 1,200 euros. For individual responsible persons of companies, up to 4,000 euros, and for companies breaching either by not appointing the person, by not establishing the channel, up to 6,000 euros for larger companies. So those are some interesting provisions of the draft proposal in Slovenia and the status.
Thank you very much, Anna. I don't think that we have a doctor from Serbia in this panel, but still, without being a doctor, Marko, what is the actual transposition status, and also if you have any main challenges maybe in Serbia related to the effective application of this regulation, would you be so kind to share with us your perspectives?
Of course. Well, it's very rare to say that we are not lagging behind the European Union in some aspects of the law. The matter of the fact is that we have the Whistleblower Protection Act put in place in 2014. So we have 6 or 7 years. It started to be applicable from 2015. So we have a significant experience in this area. What is interesting also, when they drafted this legislation, the NGOs, whistleblowing organization were involved in the lawmaking process, and it was big deal back then. When the law was prepared, it was based basically on the regulation general in UN Convention Against Corruption, recommendation of the Council of Europe on the Anti-Corruption Group, Civil Law Convention, etc. So basically on some international and European standards. But I learned from this panel today that basically the main principles are pretty much the same in our legislation, in European legislation. So basically we have the same source of inspiration, how to say. So we also have this internal, external, public kind of whistleblowing, sharing information, and also the most important for us is that this internal kind of whistleblowing protection. We also we very often receive the questions why this is so important for the companies to adopt the general acts, because you have to be aware of that in Serbia every legal entity that has more than 10 employees are obliged to have general act regarding to whistleblowing procedure, to appoint a person who is authorized to receive complaints, etc., etc. So why this kind of bureaucracy to be imposed at the companies? So we often said that this whistleblowing procedure is central for the company system of checks and balances. It shields companies from reputation and the risk, and the ability to blow a whistle reflects responsibility and the positive culture for the company. And so they have to be aware of why this is so important for them. It's not only additional bureaucracy for the companies, it is also a benefit for the company. It is they're with appropriate procedures put in place, with appropriate training for the staff of the body responsible for receiving the reports, they could level up their ethics standards and minimize some kind of whistleblowing moral hazards that could appear in the company, which are not something that you should accept. In the practice, what we learn that there are from time to time retaliation from the companies against the whistleblowers. At least what we learn that in most cases it is layoffs or terminations of the agreements. Of course, maybe the companies in some other cases or institutions using some low level kind of pressure, which falls below the radar. However, in case of this termination of employment due to whistleblowing procedure, the courts are in favor of employees. So it is very important for the companies to put the good procedures in the motion, and for the management to make the appropriate step plan and the measures how to deal with this, because in the end, it is not good for the company and it's not good for the employees itself.
Thank you very much, Marko. Quite an insightful perspective from Serbia. Maybe we could end this session on the presentational point of view with Petra, if she may maybe share with us any main challenges that Croatia is facing in the application, in the potential application, and the application already at hand in this legislation?
Sure, yes. So it is quite questionable to what extent the existing act in Croatia has come to life in practice. Namely, in general, the number of reports of irregularities is quite low. This concerns both reports to the internal reporting challenges and to the Croatian Ombudsman as external reporting channel. I believe that one of the main reasons for such a low number of reports is the fear of retaliation, which is present among the potential reporters, especially since in the media we can see many examples of retaliation against whistleblowers. So one of the challenges in practice is definitely how to encourage the citizens to report the irregularities. It is expected that the envisaged legislative changes will increase the trust in the system of protection of whistleblowers, because the upcoming act shall elaborate in more details the obligation of protection of identity of the reporters, as well as this include the exact list of actions which are considered as a retaliation. Besides, one of the common problems is that the potential reporters are not familiar with the reporting procedures at hand. In that regard, it's not sufficient that the concerned employers establish the internal reporting system pro forma just to fulfill the statutory obligation. It is important that such systems are efficient. And for that purpose, it is important to adopt very clear, transparent, and easily accessible internal policies regulating this matter, as well as to appoint educated, reliable person as an internal reporting channel who will handle the reports timely and professionally. In relation to that, from our experience, one of the main challenges is for the employers to designate who to appoint as a reliable person, especially since according to the former legislation, such person shall be someone of the employees and it cannot be a third party. In addition, in practice, we have noted also lack of education of citizens on provisions of the Act protecting the whistleblowers, in particular with respect to the conditions of protection, as well as with the material scope of the Act. Namely, from our experience, it is quite common that the reporters actually misunderstand the term irregularities in terms of directive and the Act, and actually report to internal reporting channel the infringements of the employment rights, which are subject to another procedures. So those are some of the main challenges in Croatia. Hopefully, the situation will get better with the new act coming into force.
Thank you very much, Petra. With this, we have exhausted actually the time of our webinar. And I saw that we had some questions which were answered in the Q&A panel and during the discussions. So I'm coming back to you, Harveen, maybe to close the event with a big thank you to Legal 500 for your partnership in this opportunity to share some Balkans, Adriatic and Bulgarian perspectives on the most, I would say painful legislations, especially in the compliance perspective.
Thank you, Nikolai. Also, thank you to yourself for hosting such an insightful discussion. All the panelists calling in from different regions, thank you for taking time out of your busy schedules to share your insight. I know our viewers definitely found it insightful. Now, if anyone wants to review some of the discussions that have been had today, I'm happy to let you know that the Legal 500 will upload the recording on our on-demand webpage, so you should be able to find that in a couple of days. So feel free to have a rewatch. I know there was a lot of great content covered. With all that being said, I hope everyone enjoys the rest of their day, and thank you.